Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 fundamental questions about property and property law, and today we are talking about the third question, which is using property, including how property owners have to act on their properties so as not to interfere with rights that others may have. Okay, so that is our topic for today. And we're getting to this concept of nuisance. So there are 2 kinds of nuisance recognized in the law. The first is private nuisance, which we've alluded to in other videos, and the second is public nuisance. The cases in most property law classes focus on private nuisances, but this video is intended to introduce both and to show you perhaps some differences between them. So let's start with private nuisances. Here are some examples. Air and water pollution, noise, odors, vibrations, flooding, excessive light, or inadequate light. So an example of an odor nuisance, let's say a neighbor is running a dog kennel and the neighbor does not keep the dog kennel clean. Odors go into neighbors' yards and into their houses. That is a classic odor nuisance where neighbors do not have quiet enjoyment of their property. So how about another example? I'll give a few of these. An example of a light nuisance is a bright light from a school baseball diamond shining directly into a home when the kids at the school are playing nighttime baseball games. We have also seen cases where Christmas light displays have been determined to be nuisances. This is not the ordinary display. This is those displays where people go all out in their holiday cheer. So while light might be a nuisance, the opposite of light, shade or darkness, might not actually be recognized as a nuisance. There is, though, one notable case in many property law books that differs from this general rule, and so I'll mention that one. It's a 1982 Wisconsin Supreme Court case called Prah versus Maretti. So the case recognized essentially that shade was a nuisance when it was imposed on a property owner who had solar collectors. The court in that case found that the shade from the neighboring home would interfere with the plaintiff's use of solar energy. They collected it for heat and hot water, of course, both considered to be modern day necessities. As I discussed in the video on solar rights, this is an unusual result. One item you didn't hear on my private nuisance list, if you were listening carefully, is aesthetic or visual nuisances. So this concept refers to something that is unsightly, like a pile of junk or maybe weeds that are in someone's front yard. In the past, courts have been pretty reluctant to find visual blight to be a nuisance, but that's actually changing. So weeds, for example, are a common aesthetic nuisance found by courts to be as such, and property owners have been found to have an affirmative duty to control their vegetation. You might think, well, maybe this is perhaps weeds are more than just an aesthetic nuisance. They harbor rodents, they detract from property values, and they have other effects. But their fundamental sort of nuisance-related effect is probably aesthetic. Similarly, a Nevada Supreme Court case in 2013 held that a wind turbine couldn't be judged to be a nuisance on aesthetic grounds only. So maybe not similarly, but in contrast. However, that court found that if it caused noise, a shadow flicker, property value reductions, then it might be a nuisance. So we consider nuisance law in this balancing test with a balancing test. In the wind turbine example that I used, just like the solar collector example, you might also consider how new technologies helps to develop property law, influences property law, or perhaps applies the same old property law to maintain the status quo. Okay, So now that you have those examples in mind, let's return to how the law determines whether a nuisance exists in the first place. So the balancing test concept. So whether it's defined by statute or in the court, nuisance determination almost always involves weighing various factual issues. And most often, those factual issues include facts relating to the utility of the activity weighed against the injury it creates. So the utility of the activity versus the injury it creates. So for example, it might be very useful to have a cattle feedlot in the community. On the other hand, the injury it creates might be odor, pollution, runoff into streams. So a judge in that case might look at all of the factors. It might look at those injuries. It might look at what kinds of land uses are allowed in the area or what kinds of land uses exist in the area. So a court would be a lot less likely to deem that cattle feedlot to be a nuisance if it's in the middle of a rural area versus if it's in the middle of a residential area. Just like zoning and land use might be a factor, a court might look at violations of building codes or housing codes. If there are violations, the court might be more likely to justify or to find a nuisance. Courts are less likely, however, to find that ordinary commercial uses like grocery stores are a nuisance. They might find something like a gas station to be a nuisance, but not an ordinary commercial use that is, again, something like a grocery store, a hairdresser, and so on, without something more. In general, private nuisance activities are becoming a lot rarer because of this kind of administrative regulation that I mentioned. Zoning laws, building, housing codes, also environmental laws that help to regulate activities before they become nuisances. So shifting now from private nuisance into public nuisance. So what is a public nuisance? Very similarly, a public nuisance is typically an unreasonable interference with the public's right of enjoyment, not necessarily just related to their enjoyment of property. So public nuisances are activities that affect the health, safety, welfare, or even the convenience and comfort of the general public. A public nuisance has to threaten a lot of different people, not just a few private parties or a few neighboring property owners. So here are a few examples of the kinds of things that law might define to be public nuisances. For example, a vicious dog or a type of dog, obstructing a highway, a very loud airport. Getting back to the issue of sunlight, California as a state has defined shading a solar collector as a public nuisance. So picking up on the Prah versus Maretti determination that a private nuisance exists in the case of shade. It's interesting to note that often public nuisances have public benefits. So the airport gets people in and out. The polluting factory actually employs people in the town. I also want to mention that you will hear the phrase and the concept of public nuisance in other areas of law. So, for example, the nuisance concept arises in takings law, which is covered in other videos. In particular, I point you to the 1922 case, Pennsylvania Coal versus Mann, and the dissent by Justice Brandeis. He says, and in that case involved coal mining and subsidence of houses that were located above the coal mining. He said that when there is a public nuisance, a just compensation should not be offered as a matter of course for takings law. So we're going to get to the particulars of his opinion in another video. So there you have the differences between public and private nuisances. I hope that is helpful in defining how courts define nuisances and find nuisances. But remember once again that nuisance law is often defined in state law. So I will leave it there. I hope to connect with you in the variety of ways that that would be available: Twitter, on my mailing list, through my website, and other ways. So I hope to see you next time. Thanks a lot.